Alright, we're going to get into it today. We're going to be quick, straight to the point. Let me make sure that I have everything pulled up for you guys. We're just going to briefly go over the vital things that are needed when it comes to understanding consumer law. So if you guys are new to learning about consumer law, this video is for you guys. If you guys have been studying it for a while, this video is also for you guys. It doesn't matter where you guys are at in your guys' journey. This video is going to be very beneficial to each and every single one of you guys. So I'm going to give you guys a couple minutes to go ahead and like this video. Make sure, if you don't already have the notification bell turned on, to make sure we turn on the notifications right next to the notification bell. You guys can also become a part of the mob, which is our membership level here on the YouTube, and where I go more in depth showing you guys the steps and processes for certain things that just need more insight as far as the things that we do cover here, such as specifically knowing how to file certain things. So I've dropped a lot of recordings within the past 2 years within the mob, showing you guys different step-by-steps with, these are old calls that I've done either with my mentorship, all with my mentorship. So I've dropped a lot of these calls. I just dropped a call showing you guys how to file arbitration, which that alone is hundreds of dollars just to learn. And this is going to be able to make you guys thousands of dollars, tens of thousands, by you guys properly going out and, filing arbitration. So we're going to get into the call today. We're going to be straight to the point. So I hope that you guys are all ready. Hope that you guys all have your notebooks out and are ready to learn this information. And so let's get into it without further ado. Let me make sure my mic is plugged in too. I had a couple people complaining about the volume, so give me a second. All right, let me know if y'all can hear me better. Drop a 1 in the chat if you guys can hear me way better. See, one thing about me is I'm coachable. Granted, I did not like bro's approach when it comes to how he was explaining everything in one of the comments. And a lot of you guys' comments really just make me laugh. Like, y'all send a whole book, just to get your point across. And a lot of times y'all not even getting no point across, but I do appreciate the insight, the feedback. Oftentimes I'm not always even the one reading or replying to the comments. It's my assistant who typically is, but there will be my times where I will go through them, especially when I just see things that are funny to me. And I'm like, let me just respond to this. And a lot of times my assistant doesn't know what to respond, so he'll send me it. And so that's why I really seen it. He sent me that and he was like, I don't know what to say to this. And so I do appreciate, above all else, the feedback, good, bad, any feedback, as it helps us all grow here on the community. So I'm excited to get into today's call and really break down the importance of mastering consumer law. And so, okay, let me see. And make sure. All right, feel me? So if we can see, so the title of this video, all right, the title of today's call is things that we, or what is the title? Okay. So I'm gonna get back into that. All right, for me. So today's title is Must Know with Consumer Law. So these are certain things that we must know when it comes to consumer law. We can't go out and study or worry about certain codes, receiving a remedy, what steps and what process to take if we do not understand what I'm about to cover on today's call. And so I highly advise that you guys all get your notebooks out, get your pens out, and make sure that you guys are very attentive. Make sure to also hit the notification bell if you have not already, and make sure to drop a like as well too, so we can get the algorithm of all of these videos up, because I promise you, nobody in the consumer law space is coming with the amount of information that we are coming with on a day-to-day basis, right? This fourth quarter, I promised you guys that I'd be closing it out with a bang, and we are doing such here in the month of December. And so without further ado, the first thing that we must understand when it comes to consumer law is we must understand congressional findings. See, this is what Congress found. These are why these subchapters were passed. So I'm going to take you guys through, a journey within Title 15, Chapter 41. Title 15, Chapter 41, it starts out with truth in lending. Truth in lending's congressional findings and declaration of purpose. And notice how it's a declaration and not a statement, as we're going to get into a statement of purpose here in the next subchapter we're going to cover. But this subchapter specifically is a declaration of purpose, and the reason why it's a declaration is because there's facts and there's evidence as to why these were passed. And so right away, Congress lets us know that the informed use of credit, right? Congress finds that the economic stabilization would be enhanced and that the competition among the various financial institutions and other firms engaged in the extension of consumer credit would be strengthened by the informed use of credit. So if we were properly informed upon the use of our credit, these financial institutions and other firms that are engaging in the extension of credit, because we remember, we are the ones whom is granting these corporations the right to extend credit, right? All they're simply doing is extending credit, right? Therefore, the whole system would be strengthened by the informed use of credit. But Congress then found out this, right? The informed use of credit results from an awareness of the cost thereof by consumers. It is the purpose of this subchapter, right, truth in lending, to assure a meaningful disclosure. What are certain things that they're supposed to disclose? Our right to rescind. They're supposed to disclose that the finance charge is the sum of all charges. They're supposed to disclose the payments if there were any payments, and they're supposed to disclose that insurance is also included within the finance charge. They're supposed to disclose that one cannot be denied their God-given right of extending credit, right? But they don't oftentimes disclose these things. So it's the purpose of this subchapter to assure a meaningful disclosure of credit terms so that the consumer will be able to compare more readily the various credit terms available to him and avoid the uninformed use of credit, and to protect the consumer against inaccurate and unfair credit billing and credit card practices. And so I don't know about you guys, but within the Billionaire Act of 15 U.S.C. 1666, which is also within truth in lending, right, there's a whole act that these corporations are supposed to abide by in terms of if they do bill you guys. Furthermore, they're going through and utilizing inaccurate and unfair credit card practices. The fact that we are even making payments in general, that is unfair within itself, right? I don't know about you guys, but what benefit are you guys receiving from you guys already crediting them something and then paying month to month upon something? And I want you guys to understand that anybody that's ever invoiced you guys, they themselves are also a debt collector within the FDCPA, which we're going to get in here in a second. And so what I want you guys to understand within congressional findings of truth in lending is that The whole system would be strengthened if we consumers were properly informed upon the use of our credit. Now we're going to get into congressional findings of the FCRA. So within congressional findings of the FCRA, this right here is separate from the other subchapters, as this is a statement of purpose rather than a declaration of purpose. See, it's a statement of purpose because Congress is leaving up to us to define what is fair and what is accurate. Because right away within 15 U.S.C. 1681 in parentheses A, accuracy and fairness of credit reporting, Congress makes the following findings. The banking system is dependent upon fair and accurate credit reporting. I want to stop right there and just look at the word dependent upon. To be dependent upon something means to not be able to live without it. So if a baby is dependent upon their mother's breast milk, they cannot live without that breast milk. See, what I want you guys to understand is that the banking system is dependent upon our credit. In simple terms and simple words, that's exactly what the first sentence is stating. I want you all to go look up in the Black's Law Dictionary the definition of accuracy and the definition of fair. Furthermore, they talk about inaccurate credit reports directly impair the efficiency of the banking system, and unfair credit reporting methods undermine the public confidence, which is essential to the continued functioning of the banking system. See, I want you guys to go take a look back at what took place in the 1929s to 1930s. Throughout the 1930s and 1933 specifically, the United States Corporation entered its fifth international bankruptcy. See, what I want you to understand is that the public lost confidence within the banking system. So therefore, them mentioning unfair credit reporting methods will undermine the public's confidence. If we look at what just took place with Toyota Financial, Toyota Financial is getting hit with a $60 million lawsuit for unfair credit reporting methods in which they're using against consumers. So it's not only them going out and exercising and using illegal lending tactics, but they're also reporting unfair credit reporting methods upon individuals' consumer report. So these are things that have been going on not only in current day, but since the 70s when these acts were passed. Number 2 states an elaborate mechanism has been developed for investigating and evaluating the credit worthiness, credit standing, credit capacity, character, and general reputation of consumers. See, what I want you guys to understand is that Congress is calling them an elaborate mechanism, them being the consumer reporting agencies, and they're the ones whom are evaluating the credit worthiness. So think about credit worthiness, whether you're worthy enough for things in which you're granting these corporations in the first place. Credit standing, that could be AKA a credit score. In essence, credit capacity, the character, general reputation. I want you guys to think back to the first thing that they have stated and called these corporations being an elaborate mechanism. That's highly disrespectful to call another corporation an elaborate mechanism, but that's all that they simply are. Number 3 states that consumer reporting agencies have simply assumed a vital role. So if I assume that I'm the head coach of the Eagles because I got, players gear from the Eagles, does that make me a head coach of the Eagles? Indeed, it does not make me the head coach of the Philadelphia Eagles. Granted, they could probably use some help within these past couple weeks. But no, that does not make me the head coach because I assumed that I'm the head coach of the Philadelphia Eagles. The consumer reporting agencies have assumed a vital role in assembling and evaluating consumer credit and other information on consumers. So all they're doing is assuming this role. Number 4 states, so what power do they truly have? But the power that you guys give them, and you guys give them power, and they stand in that power when we call them a bureau. They are not a bureau. See, they're simply consumer reporting agencies, so call them by their name. It's like if I call you guys out of name, you guys aren't going to respond, hopefully. I'd hope not. My best friend who plays for the Eagles, if I call him Slay, I guarantee you he's not going to respond. Granted, he's 2-2, number 22, instead of just 2. His name is not Slay, right? His name is Keely Ringo, and so he's going to answer by such. And so I'd hope that you guys are going out and calling these consumer reporting agencies, Equifax, Experian, and TransUnion, as such. Consumer reporting agencies, because that's all that they simply are. Number 4 states there is a need to ensure that consumer reporting agencies exercise their grave responsibility. Now we're talking about a grave responsibility. See, you guys got to pay very close attention to the wording in which we're using. Grave, think about a grave, right? What is a grave? What is a graveyard? Right, we're talking about life or death now. So they can literally be, put in a graveyard by not following these and exercising their responsibilities with fairness, impartiality, and a respect to the consumer's right to privacy. They then do not define the term right to privacy because it's a statement of purpose. It's for us, the consumer, to define, our privacy and what is private to us and what's not private to us. And so this is the congressional findings within the FCRA. We must understand the FCRA to truly go out and get anything removed from our consumer report. I promise you guys, just with the understanding of the FCRA and specifically the congressional findings, you guys can and will get anything and everything removed from your consumer report with using and exercising the FCRA. See, the FCRA is simply all that you guys need to get anything removed. So I would study the FCRA, know the ins and outs of it, and get more familiar than any other subchapter to get anything removed from your guys' consumer report. And last but not least, let's say you guys are dealing with these third-party debt collectors, right? These third-party debt collectors or once again, let me specify this, any financial institution or any corporation, dang, we just ran out of space on this memory card. Any financial institution or any corporation attempting to collect any debt themselves is also a debt collector. So what I want you guys to understand with the congressional findings and the declaration of purpose, right, there's facts and there's evidence backed by this, that there's been an abundant evidence of the use of abusive, deceptive, once again, these are not defined, so Congress is leaving it up to us to define how we've been abused, how we've been deceived, how these corporations have been using unfair debt collection practices by many debt collectors. Right? Abusive debt collection practices contribute to the number of personal bankruptcies, to marital instability, to the loss of jobs, and to the invasion of individuals' privacy. So we just talked about privacy here in the FCRA. Now we're talking about privacy again within the FDCPA. And I promise you there's many tactics in which they are using, in which they're invading upon your guys' privacy as an individual, as a consumer. And so we must understand the ins and outs of congressional findings before we even think about going into the definitions, before we even think about going into any of the other codes in which we can find here within each one of these subchapters. Then we talk about interstate commerce, right? Why I mentioned, us talking about interstate commerce, right? And let's read what it says real quick. Abusive debt collection practices are carried on to a substantial extent in interstate commerce and through the means and instrumentalities of such commerce. Even where abusive debt collection practices are purely intrastate in character, they nevertheless directly affect interstate commerce. The reason why I bring this up is because everything is commerce, everything is business. The United States, once again, is a federal corporation and pursuant to 28 USC 3002. So we got to understand that everything is simply commerce, and you got to understand and know how to operate throughout this organization, and how to separate yourself from the fictitious entity in which they've created for you, on your behalf, in which you guys have been acting in suitorship and jointer with this corporation when you guys as a natural person, are backed full in faith by credit. You guys are the creditor in fact, but they've deceived you guys and misled you guys by, making you guys believe and construing you guys into believing that you guys are this all cap organization when in fact you guys are not this organization. You guys are a natural person, but being a person, you can wear the hats of both the natural person and or the organization. And so I'm going to get into showing you guys as well too with my business partner Taquan X. I do it highly advise that you guys hop into his channel to really get more of an insight upon status change. And come 2024, me, CreditGotti, will be showing you guys the secure party creditor process. So definitely stay tuned to all of that and becoming a secure party creditor. That is where you will, become the administrator of that organization and corporation. And that's where you'll place a lien on the state and, take the steps to truly operate in the private. So a lot of us are looking to operate in the private. A lot of us are looking to have private organizations, which I've been setting up now for the past 2 years, that being a 508c1a. And so if you guys are looking to not only set up a private organization, but operate in the private, come 2024, I will be teaching that. In the meantime, I will reference you guys to a great place that I did learn from, and that is Yusufel, High Frequency Radio. Then you guys can find him at SPC University and or his YouTube channel at High Frequency Radio. I don't have no affiliation with them, but I always give credit where credit is due. That's all that I have for you guys today. These are things that we must know when it comes to consumer law. We must understand the congressional findings before we get into any of the juicy stuff within each one of these subchapters. Right? We see many different violations just alone by looking at the overview of the FDCPA: harassment or abuse, false or misleading representation, unfair practices, validation of debt, multiple debts, right? Legal actions by debt collectors, civil liability. Before we understand any of this, we must understand congressional findings, and then next we must understand the definitions, right? Do not go anywhere without understanding both of those two. And if you do not understand those two, it's time to get to the drawing board and master the basics. Right, family? So that's all that I have for you guys today. I do appreciate everybody tuning in. Peace, love, and light. And as always, I'll see you all at the top. Y'all know why, man. Because the bottom is way too crowded. CreditGotti's out. Let's see. We got a couple questions. How do I hold a dealership? Let me take it off this. How do I hold a dealership accountable for deceptive practices? There's too many violations to even put here. But the thing that has me the most heated, I had a co-signer who they put as a buyer on the contract. I didn't get the contract until almost 2 weeks later, and when I did, it was stamped with retention only. I asked about that, and they said it was their policy, so I don't even have an original contract. The car was listed as $1,440. I got approved for $20,000. Let's see. The car was listed as $1,400. I got approved for $20,000, and so I was given a $4,000 service contract. I didn't ask for it, and I wasn't told that the service contract was with another party financial till I have no service contract. And so that sounds like a lot of fraud within specifically truth in lending. And so I will look up that finance charge and look through all of truth in lending. We have the overview here on the channel. So go through the truth in lending overview. On the truth in lending overview, there's many violations that you'll be able to find. And the thing when it comes to, you guys explaining and giving an insight upon your guys's, journey and story, as a whole, is beautiful, and I love the insight, and I could direct you guys towards which subchapter to really study and get familiar with. But at the end of the day, you got to do the reading to see, how and what you've been violated with. Yeah, so definitely a whole lot of fraud, because you guys were the ones who was present throughout the transaction. I wasn't present, and so it's a lot more powerful. And this is where the power does come in when it comes to you guys knowing consumer law. And no, do not get a lawyer. You don't need a lawyer. You just need to know truth in lending. Go watch the overview, join the mob, and watch the overview of the FDCPA. Right, the FDCPA is what we just covered here in 1692. So we went over the 3 subchapters, the big 3. And so with the first one and the last one is where you'll want to look. Just coming here and looking at the overview. So let me take you back here. So just coming here and looking at the overview of the FDCPA, communication tactics, harassment or abuse. These are all ones in where you can find false or misleading representation. Right, let's come here. I guarantee you will find one. A debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt without limiting the general application of the foregoing. The following conduct is a violation of this section. Right? The false representation of A, the character, the amount, so any amount, so them telling you that you owe anything, that is a violation within itself, number one, or legal status of any debt. Let's see. Any services rendered or compensation which may be lawfully received by any debt collector for the collection of debt. Understand that these dealerships, these financial institutions, as I just broke down, are also debt collectors themselves. Let's see. So this is for my people that have repossessions right here. 12. Let me see. Also for my people with repossessions. So there was 2 within there specifically for your case. Let me see. You're really going to want to get hip with truth in lending with yours. So you can break down the disclosure guidelines, certain things they didn't disclose to you. You're going to want to really get hip with the finance charge. Everything that they added, the fees, if they had you leave with insurance, all these things are included within the finance charge. So get familiar with truth in lending. Learn how to hold them not only civilly liable, but criminally liable for giving you false or inaccurate information. You just mentioned how they gave you inaccurate information, how they gave you false information. And I promise you, they definitely do got that original contract. And if not, what I would do is I'd come back here to 1692 and I'd have them validate this debt. I'd request each one 1 through 5. After that, I'm going to request C, admission of liability. The failure of a consumer to dispute the validity of a debt under the section may not be construed by any court as an admission of liability by the consumer. So definitely get familiar with those 2 subchapters, and that'll help you big time in terms of keeping the vehicle, but also getting that debt discharged so that you're not obligated to making any payments. All right, family. Let's see. Hey, brother, I applied for an Amex green card. He got denied for not having any credit history. Should I write them an adverse action or just go to the secured? So I would still go through with the secured. I mean, if you don't have any history, you can add on some accounts with Rental Karma, Rent Reporters, Credit My Rent, any one of those 3, that'll help big time. If you got anybody in your family that you could get added on as an authorized user, you could definitely do that as well too. An authorized user will help with some history. Make sure that their utilization is low, and low being below 10%. Make sure they have 100% payment history, and make sure they have a good limit on that card as well too. And then 2, and that could stop you from even having to do that secured card. If you got the extra remedy, if you got the extra capital, you could definitely do a secured card. I'd recommend doing a secured loan rather than a secured card though. Just thinking about what is more difficult to acquire, a loan or a credit card. That loan's going to be, and your report will thank you in the long run. So I would do the secured loan always over a secured card. Let me see. And still draft up that adverse action letter though for them. So watch those 2 videos of how can one be denied their God-given right. I got a part 1 and a part 2 on those. So I would definitely check those 2 out. And I just did another video. We got like 5 videos on a denial of credit. So check out all of them. I give you guys letters and what to state exactly verbatim to them. So I would definitely check those out as well too. I hope that helps my guy Alex. I'm learning how almost every Yeah, every single contract is fraud from the past 8,500 years. If y'all really want to learn and really break these contracts down to the T, go study David hyphen Wayne WYNN Miller, David Wayne Miller, right? He educates people upon correct parse, syntax, grammar, and so that's what I'm still learning myself, and that's what I'm teaching a little bit within my mentorship. Oh yeah, they haven't given me plates, but I got the title in the mail yesterday. All right, family. So I'm not sure who's on here anymore, but the laptop did just die. So we're gonna call it a end for this live. Be out, family. Peace, love, and light.